Somebody call a doctor.
I want a bigger logo. You can't handle a bigger logo.
And good day. This is the Dr. Branding Podcast. I'm your branding Dr. Frank. As always, the surgery is open. We're on air. Let's answer our next patient's question. So today comes from Sam in Australia. Do I need to protect my name and logo? Is it just covered by copyright, or do I need that little R symbol or TM symbol? Help, doc. From Sam in Australia. Sam, thank you for the question. Same name as my wife. Okay. Sam, in terms of your brand name and logo, registration of these things can be done in many different ways. But just like IP protection of something like a patent or copyright for things like a book or music where it has a limited run of copyright, I think it's like 50 years or something like that, you can register something like your name and your logo for a certain amount of time, depending on where you're based. But Sam here is in Australia, and I'm familiar with IP registration in Australia. But in terms of a diagnosis, I guess for this situation, whether or not you need to or not, I'm going to call this Protectorbranor. Okay? Protectorbranor. It's the uncertainty of whether or not you need to register and protect your brand assets. So this could be things like your name and your logo. It could be characters like a mascot, or it could be sub-brand names or certain processes that you could register the name of as well. Things like that, okay? But before I get into prescription for Protectorbranor is to say that I'm not an intellectual property lawyer. I'm just a branding doctor. Basically just a brand services provider. But this is who you would turn to for something like this to protect your brand if you want to do so. You want to go down the road of protecting, say, the name and the logo, in this case for Sam. A intellectual property lawyer. You could do a quick Google search and I'm sure you would find somebody in your location that would do so. And the role of an IP lawyer is to make sure that what you have can be protected. There isn't someone else's toes that you're going to step on out there in the market that already has that name or a similar logo, and that your registration process can go through successfully without delay. And that process, can take a few weeks to a few months, maybe a year, depending on any pushback from anyone that might want to dispute your registration, which is something that can happen. But I'll get into the nuts and bolts of that in a second. But that's what an IP lawyer will help you do and take you through the process to tell you if it is worth doing and how to do it and the ways of doing it, and obviously the cost as well to do it based on where you are in the world. In Australia, there is a cost involved in registering, but we'll come back to that in a sec. So with something like copyright, is it covered by copyright was part of Sam's question. And based on the work that you create, so created works do have an inherent copyright, or in some cases moral rights, especially if you're a brand designer, where you have some form of ownership of the work that you have created, that it was created as is. It wasn't derived from something else that can be seen as clear influence and copying of another created asset, a created work. This is my understanding, that it can effectively have some form of copyright to it based on the date that you had created it. As long as you you haven't gone and Google searched something on, Pinterest or whatever and found a very similar logo and gone, I can just copy that and, tweak it, a little bit or whatever so I could get away with it. That looks like it's based in another country. I'm based here. It's not a very good way of making your logos. But in terms of a name, there is another way, I guess, of having some form of protection. It's not quite copyright, essentially, but it is more a case of business registration. So in Australia, you can register your company name or your partnership or your solo business with an ABN, and you can buy I think it's either 1 or 3 years, you can buy a business name that can be attached to that ABN, so that Australian business number. So this might be the same case in other countries where you can register a business name, and that might give you some protection based on the date of that registration. If nobody else had it, if the business registration service allowed you to register that name, so no others in your country or your state maybe or county or whatever it is had registered that name, you might have some protection there. So that's naming in essence, but without, say, registering something in some form where it's a public domain that someone can search at least to find out if no one else has that name already. So let's say you've got your name and you're using it on your website, your social media, and things like that. And someone goes to register that same kind of name, if not the exact same name, and they don't see it in a business registration naming thing or in an IP registration database, and they go, well, can we use it? It's open to them to take that name effectively, even if you might have already used it. But this is where it gets a little grey. And I don't want to get into the nuts and bolts of those specifics, as it's better off talking to an IP lawyer if you go to register a name, let's say, and you see someone else using that name already, but it doesn't come up in any of those databases, especially for the Australian business registration for naming. And then the same thing for IP Australia for registering a trademark for a name or for a logo. Nothing comes up on there. You might be able to still register it. But if there is someone else out there, another business that is using it, hasn't registered it, this is where it's best talking to an IP lawyer, I believe. So there's those kind of instances where this could get a little bit grey, and there might be a bit of dispute on that. Who knows? It really comes down to the unique scenario that you're in, where somebody might have come up with the same name, might be using it, or you vice versa, you're on the other side of the coin. Okay, leaving that aside, the things that I do know that you can do. The first one is trademarking, and you might have seen that little symbol TM on a lot of logos or naming conventions, be it a character name, be it a business name, sub-brand name, whatever it might be. Even for things like movies like Star Wars, a lot of their characters like Luke Skywalker and Darth Vader all have a little TM symbol. And that is to say that this has an intent to register, and an intent to register a trademark in this case. So if you are planning to obviously register, you've created your name and logo, and you are going to then go out into market and you want to register this bit of IP, this name or this logo or whatever it might be, you can slap on a TM. You can get your logo designer to put a little TM in the corner, say top right or bottom left or bottom right, wherever it is. Something that's appropriate, or next to the name when it's written out, to say that this is a trademark, or just the name and then TM. All that shows is just intent to register with something like IP Australia here in Australia, or something in your country, in the US or UK. I'm pretty sure there's going to be a registration place to do that as well, for at a kind of federal level, at a country level. Yeah, country level. So that's the TM part. What you want to go for, I guess, to have the maximum protection for your logo and for your name is full IP registration. And this is where you have the little R in the circle, much like the C in the circle, registration. And you would do this, Sam, here in Australia at IP Australia. You can give that a Google and you'll find a whole database of names that you can search. You can even do logo search. So you could upload your logo in black and white, and it will give you a whole selection of logos that it thinks is similar, for you to see if you're treading on someone else's toes. If it's too similar to somebody else's, it's a better bet to go and change it before you register, for sake of losing your money on registration and it being knocked back, or someone disputing it and then you having to go and change your logo, and you've wasted a bit of money on trying to register. Now, with registration, as I said before, you do need to pay for it and pay for it in certain ways. So if you do it yourself, you by all means you can do it yourself. I've had clients that have just gone on, uploaded their logo or registered their name, gone through the motions of the process and pay the money and waited for a determination from their IP Australia organisation, and you get your certificate and away you go. But one thing you do need to do is a thing called classes. And this is the same, I believe, in other Western countries, at least, where you have classes of IP registration. Now, this is based on your industry and certain subclasses of those industries. So say if it's food and beverage, you might have subclasses for fast-moving consumer goods, so like a soda can, things like that, or everything to a restaurant, all in that one class. And then you have subclasses of those different FMCG and restaurant or pub or brewery for a beer, those kinds of things. So there's a whole myriad of things. And you might have a business that applies to different subclasses or to different classes entirely. You might have such a diverse business that it could apply to multiple classes where you can register your IP, be it the name, be it logo, and other assets. The one thing though, the more classes that you do, I believe the cost goes up as a result. So per class is a certain fee on top of the registration fee to begin with for it to be reviewed. And then you go through the motions, of paying whatever that registration is. And then it's set for a certain amount of years. I think it's either 5 or 10 years that you have that registration for. It might be longer. Please don't quote me on that. Have a look up at what IP Australia's results show you, or speak with an intellectual property lawyer. But that's basically the process of registering a logo if you want to go down that route, and that will give you maximum protection in terms of being able to send a cease and desist out there to somebody that does infringe on your intellectual property, be it your logo, be it your name, and that way you can protect your IP, which is your brand. And protecting your brand assets, I think, is very much a worthwhile cause, so that someone isn't raining on your parade, obviously, and just ruining your business by someone getting confused is it your business or is it somebody else's business. That's what we're trying to protect against. And we don't want someone coming in, especially on purpose, trying to mislead a consumer to think it's you when it's not you. And that happens very unscrupulously, obviously. But it can be by accident in some cases, let's say, not meaning to infringe, but it can. And there's very, big examples to small examples of IP registration infringement. Bigger corporations are very much dedicated to protecting their brand, and they will do so with their full suite of lawyers that are on retainers, paying by the hour, and they want to use them and make use of them so that they vehemently protect their IP, because their brands are worth lots to them. Anything from an Apple to a Coca-Cola to a McDonald's and everything in between. They vehemently protect their assets, just like you would your home. If someone was invading your home, you don't want to let them in. You don't want to let them steal and rain on your parade in that way, yeah? So it's the same kind of thing. And Apple has done that in classic examples where you can still protect your IP, especially if it doesn't look anything like anybody else, but someone might feel like that logo that you've made could be misleading to a consumer that is in a similar industry, a similar class, that could be mistaken. And I'll give you an example in Australia, because Sam's based in Australia here. Apple went after our biggest supermarket, Woolworths. Again, not a small business by any means. They're one of the biggest businesses here in Australia. But they rebranded, I think back in 2005 to 2007, something like that. And they changed their logo to have this green swirly W with a little apple accent at the top. And it was just supposed to be like a green apple skin spelt out into this nice swishy W, to be the W for Woolworths. And because the overall shape of it is an apple and has the little quiff up the top there of the little, I don't know what you call that, the little wick kind of thing that comes out of the top of the apple that attaches to the tree. very much similar to Apple's in a way. And Apple, again, has been around much longer. It has the Apple bite taken out of it, originally designed by logo designer Rob Janoff, someone I've had the pleasure of meeting and interviewing in a podcast a few years ago. Apple, took him to court and stressed that Woolworths was in the same kind of market as what Apple is. Woolworths can sell phones and sell other devices and things like Apple can, and offer similar kind of services in a way, I guess, and could be misconstrued for, someone could see a Woolworths logo and think that that's Apple as in the technology company rather than Woolworths, the Australian supermarket. It could happen. And that's what Apple is banking on when they tried to take Woolworths to court. Apple was unsuccessful, but it just shows what they'll go to. And I've heard of Apple doing this with other cases, even a small app that was on the App Store that used a little pear-shaped kind of logo. It had a little bite out of it. Again, Apple cease and desist through their lawyers at it. Things like that. It can happen. So you guess you've got to be wary of protecting your IP, but also wary of others feeling like you're stepping on their toes and infringing on their intellectual property, especially when you go through the registration process. You might discover that someone's out there wanting to just as much, if not more, wanting to protect their IP. So again, just to be wary of it. The case of whether or not you do this is totally up to you, Sam. And for those of you listening, obviously, whether or not you do this. And I'll give you another point as well for those of you who are brand and services providers like myself. If you're helping a client with a name, with a logo, you can do a bit of due diligence by going on to, say, if you're an Australian branding services provider, or even in your country, you might have the same kind of service. Go to IP Australia, type in the name that you might have created, or upload the logo. And you can do this on Google searches as well. Do Google image reverse search, and see if those assets come up something similar. If it comes up similar, then you've got to go back to the drawing board before you present those assets to a client, and that might be just the amount of due diligence that you can have. I would stress in your agreements as well to have a little clause in there that would say something like you do your due diligence to do your best to create an original work that doesn't infringe on copyright to your best extent of a simple search via those particular services, but it doesn't constitute the ability to do a full extensive search and requires your client to engage with an intellectual property lawyer for a full search and determination whether or not this can be registered. Something like that. Again, I would talk to a lawyer in that case, someone that can help you write your contract and put something like that into your agreements. It's not a hard line against a client. I think that's very reasonable to have because, again, we're not IP lawyers as branding services providers. We can do our best to put a name forward. We could do a search on Instagram and social medias to see if the handles are available for a name and domain searches for a domain name, things like that, obviously, too. But when it comes to something like a logo, if you're doing it from scratch, from your head, from your own thoughts, there always is a chance that somebody else already has a similar looking mark, if not fully the same, if it's a really simple mark, let's say. So it's something to be wary of. And I think that offering a little bit of due diligence of doing your own little search, seeing if anything does come up in the first kind of case scenarios without having to engage an IP lawyer. But I will say, though, there are IP lawyers that have approached me and offered a free service as a services provider, a brand services provider, that you can engage with them as like a partner and refer clients onto them. So they could help you do a quick search, see if the logo gets a green light, and then refer the client on that you've been working with to then help them register their logo or brand name or whatever other assets that could be registered with something like IP Australia. So maybe engaging with an IP lawyer might be a good little connection point for you as a brand services provider. A quick Google search will find you one in your area. and you go from there. So look, I hope that really does help you, Sam, and those of you listening. There's a lot of different points that I kind of darted around at the end there. But again, IP registration is something worth protecting, definitely, especially as your business does grow. If you can do it the earliest possible chance you can, if you have the capacity to do so, both financially and the time to do so, I would encourage it. Absolutely. It is worth protecting. We don't go through the motions of branding and everything for it to be trampled on by someone else that comes in and, again, as I said, throughout this, rains on your parade. So, Sam, thank you again for your question here. I do hope that helps. And those of you listening, look, please take a piece of Brand Candy, my free resource guide to do better branding that you can get on your way out at g'dayfrank.com/candy. You can also make an appointment via that link if you have a brand-related ailment that you'd like some help with. And I'll see you at the next appointment in my next episode. Bye, everyone. Thanks for listening. The surgery is now closed. The Dr. Branding Podcast is hosted by Reagan Frank McCrill, that's me, and for legal reasons I want to be clear that I am not a registered or qualified doctor. The premise for this podcast is that it is a satirical analogy for branding consultancy to help others with their brand success. This podcast is also sponsored by my branding business, G'day Frank. Say g'day today by booking a call with me at g'dayfrank.com.